Yes, people. Okay, listen. Now we'll be discussing the mock test paper that we had for chapter 1, 2, 3 and 5. So if you look at it, chapter 1, 2, 3, 5 is actually there is nothing conceptual. Everything will be a little drier. But in this only, what type of questions you can expect and what are the challenging questions can come. That's why in some questions I touch the case laws also, wantedly. Correct? Because I know none of you would have written in the entire class. If someone has written, that means you take it for granted they have copied. No, they would have said, okay, I'm sorry. Okay. I'm sorry, Yogita. Who has written case laws, Zelda? All of you wrote case laws. My God, you are proving me wrong. See, दुश्मन कहाँ है बगल में देखो. Okay, now see da. आयत नोड्रो. Par. What is the necessity of pre-certification of e-forms? First of all, tell me what is pre-certification of e-forms? What does it mean? It was introduced with the motive of reducing the workload of the registrars. So, what is pre-certification? Nothing but certain forms has to be pre-certified by professionals. What do you mean pre-certification? Without these signatures, these forms cannot be uploaded on MCA website. If these forms are there, it will not be accepted by the MCA at all. It will be signed by the professionals like PCA, PCS, PCMA, in some cases, advocate. Correct? Yes, sir. Now this is only called as what? Pre-certification. Sir, can I be fraud? Can I take money and certify it is true? If you do it so, you will be liable under section 447. That is fraud. Correct. So that is 447. That is called fraud. If you guys have written all of this, then you guys will get 5 marks. Here, simple, hello. Okay, next one. What is the difference between veto power and casting power? I have not done highlight here. Okay. In case of equality of the votes, chairman may give vote either in favor or against, and it will be carried accordingly. Veto power means people to refuse or to admit to or approve, or you can also write I forbid. If that is written, then you guys can give the mark. Clear?
Now this differences and on questions, can we write actual like in a table format?
If you have so much of content to write it in a tabular format, write it in a tabular format. Now for example, MOA and AOA and all. But if you look at guideline answer, they give it to you in tabular format only. So write it in tabular format only, table format only. That's what you write. If it's I forbid is there, give them a mark. Clear? Okay. I forbid is there, give them a mark. Okay, now people, what is veto power and what is casting out, people? What is a veto power? Veto power is nothing but which speaks about a power given to a specific people, that is the shareholders, to say no, we do not want. That is only we forbid, I forbid. That is called as veto power. What do you mean by casting out? Casting out means it's a vote given to a chairman of the meeting whenever in the case of equality of votes, when for and against are same, 50-50, whatever vote the chairman gives. If it is for, resolution is passed. If it is against, resolution is not passed. Clear?
Exactly, you have to write if this or the difference between.
You can write in table format. Clear? You have easiest one. Next one. What has been the approach in India regarding the enforceability of shareholders agreements? Justify the statement with case laws wherever applicable. What is it they're trying to ask you, da? What is the question? MOA. They're asking you, what is the enforceability of shareholders agreements in India? Basically, this is a statement taken between whenever there is a conflict between AOA and SHA, which document will prevail. There are various cases where in few cases they have said SHA will prevail, in few cases they have said that AOA will prevail. But what is considered in the case of Rangaraja versus Gopala Krishna, in this case Our Supreme Court has held that what? Whenever there is a conflict, it is always the AOA that will prevail. Then what is that you need to do to be safe? Whenever there is alteration, whenever there is a shareholder agreement that you enter, we saw Shark Tank episode and all, it is always wise to bring in all the terms from shareholder agreements and put it into articles of association to be safe. That is what was communicated in Rangaraj versus Gopal Krishna. One more important case law will be Measures Holding Limited versus Shyam Madan Mohan Ruya. What was discussed in this? In this one, they held that SHA can also be held valid because it is agreed by the shareholders only. So we have cases against also, for also. But end of the day, which one will prevail? Supreme Court, Article 141 of Constitution of India, Supreme Court's thing will prevail. So Rangaraj case will hold more value when compared to the other cases. If other cases are not there, is also okay. Rangaraj and Measures Holding Limit is there, give them mark. If not, ICSI, take it away.
I wrote one name correct, one name wrong.
Take it away, don't give mark. Whoever has her paper. You got your paper, Someone got Sudarshini's paper, no, take away that mark from her. What is the enforceability of SHA in India? So in which context you saw this? No, they have asked you, right? In India regarding the enforceability, meaning is SHA, correct. What is the context is what they are asking you. Where will they ask you, if you guys enter into an SHA, will that be valid or invalid? Which was the context? Enforceability means what? Is it valid or invalid? In which context you saw that? And to give you a hint, they are also giving you, asking for case laws. Where else you saw case laws? In this context only. That is what, you need to see this also, no? Why are they asking case laws then? Correct. And this is also, you have to read entire question. Hey, no. Sudarshini is, whoever got it, remove that entire 5 marks. 1 mark also don't give. People, fourth question, Zeta Motors Limited has a mix of equity and preference. The company recently proposed changes to the rights of one class of shareholders through a special resolution. The articles of association mention provision for variation of shareholder rights. The affected class of shareholders approved the variation by a 3/4 majority in a separate meeting. However, after variation, some other shareholders claimed their rights were impacted and raised objections. Based on the Companies Act, discuss whether variation of right is valid and what additional steps, if any, should have been taken. What is the section? What is the question? What are they asking you? Section 48, variation of shareholder rights. So, section 48. Where did I make you write the rule? In 48, which SEBI rule you wrote? Rule also, which SEBI rule you saw? Regulations you saw? Dey, nee parada inge. People, now see da. Dey, variation of shareholder right. 3 things you need to remember. What is that? People, now concentrate da. If at all you are changing variation of shareholder rights of preference shareholder, wanted they are given there are 2 types of shareholders, macha. For a reason they gave you both. So they are changing one set of people's rights and they are telling you others have an objection on it. So whenever variation of one right of a shareholder is changed, what is the way to do it? 3/4 of issued shares or a special resolution. Section 48. You need to get approval from 3/4 of the issued shares or special resolution. If it is affecting others, you need to pass a special resolution in other class of shareholders meeting as well. So if preference is being altered, if it is having an impact on equity, you have to pass special resolution in equity also, special resolution in preference also. If at all there is any objection of how many? 1/10. They can any day go and object in a tribunal. Correct? That is the answer. So in this case, if at all the objection is from other class of shareholders, then do not pass special resolution. That is one. Second one, if the same class of shareholders have a problem, then if 1/10 the people want, they can go and object it in the tribunal. Whatever the tribunal's order is, it will be final. Hello? Correct? Yes, sir. Now, one more thing. If at all I need to vary my shareholder rights, the power of variation should be given in MOA or AOA. Correct? Or there should not be any objection in the offer letter that was issued by the company. This or that. In this case, for a reason they have said articles of association provides for variation. Understood?
Should we write the other thing on?
Not required. You can just write that one. But 6 marks, no, you can write. You can write because 6 marks. 6 marks is actually more. Kira, hello. I don't know how many of you wrote what. Arkan Limited recently acquired Arkan. Okay, answer. The company is MOA, AOA. Allow for such variation? It allows, no. The variation is approved by 3/4. Correct? Or a specialization note? Affects other class, then you need to take the approval from the other class as well. Correct?
So should the company do anything additionally?
For objection means a company need not do anything. The shareholders will go and object it in the tribunal.
The question is asked if they followed the correct procedure.
Is that they have asked? Based on discuss whether variation of rights is valid and what additional steps, if any, should have been taken.
Any additional steps?
Some other shareholders claimed their rights were impacted and raised objection. Company need not do anything. Shareholders have to do. Correct. It is shareholders part. Company has nothing to do. That you need to mention. Tribunal part also will come into picture. No. You just write 1/10. Minority majority will go to different topic altogether. Clear? They online now. Okay, Jadado. Arcon Limited recently acquired a 70% stake in Beta Technologies Private Limited, thereby making its subsidiary. After the acquisition, during a routine review, it was discovered that Beta Technologies holds 2% of equity shares of Arcon Limited. A few directors raised concerns regarding the legality of this shareholding in light of Companies Act 2013. Can Beta Technologies legally continue to hold shares in holding company Arcon Limited? Justify your answer with reference to the applicable provisions. What is it? There is something called as Beta Technologies. There is something called as Arcon Technologies. Arcon applied in Beta 70% of stake. However, in the past, Beta had already acquired stake in Arcon. How much? 2%. Now they're asking you, is it valid? Is it legal? Section 19 says that a subsidiary company cannot hold shares in its holding company. Exceptions where you can continue to hold as a trustee and in the capacity of a legal representative you can continue to hold. Third one, if you were a shareholder even before you became a subsidiary company, on those grounds it is valid. So there is no other thing required. It can continue to hold. Agreed? Hello? See, all keywords are there. If it is there, give them mark. If not, just take it away. Don't even give 1 mark. Next one, under what circumstances can Indian courts lift the corporate wheel? Explain any 3 such judicial interpretations by quoting relevant case laws. Lifting of corporate wheel down. First one was what? In the case of alien company, Daimler company versus Continental Rubber Tires.
If you want like citation, the entire thing, but just we write
You write just a?
for the Daimler.
No. Case law is there, you should write full. That is from book point of view, not from our point of view. If the book has written that, you will also write that much. Yes, people. Hey, okay, see, Daimler company you can write, and Workmen Associated Rubber Industry versus workmen of Associated Rubber Industry versus Associated Rubber Industry. That was for
Escaping legal.
legal obligations. If you are escaping from legal obligations, tax evasion, Dinsha Manakji Petit. You can also read Vodafone case law. 3 sufficient. Yes sir. What else was there? Subsidiary to act as an agent.
Fraud.
British Transport Commission versus Merchandise Transport Limited versus British Transport Commission.
If I'm not understand.
Clifford versus Mercer Horn for fraud.
Fraud and fraud.
Case law you can write. You got her paper, huh? If not, just change it off now only. People, who got Sudarshini's paper, huh? You got it, huh? Hey, be very strict, huh? Hey, macha, I will also check that paper. If at all I cut 1 more mark, 2 more marks means I'll get to know.
My paper is the fraud.
Who? Anaga, is it? You got his paper?
So, is the explanation of case law can be done or just can write a case law?
No, you need to explain alien enemy and then write case law. Case law need not be explained.
Just the name is
Okay, concentrate. Twilight Innovations Private Limited. Your next exam will be on Sunday, da? Now the coming Sunday. Your birthday means 2 tests you write. Now this coming Sunday test. Whatever day, already general meeting is done na. Directors is done na. This 2 only is very big enough for you to take up a test. Okay, now that on Saturday we will fight. Now see. Twilight Innovations Private Limited is a private limited company engaged in software product development. The company was incorporated in 2020 and has shown significant growth in recent years. As per the audited financial statements for the year, the following data is available. The paid up capital of the company is 3.8 crore. Turnover is 39 crore. Net profit is 2.2 crore. It holds 60% of the share capital in a recently acquired startup. Critically examine the status of Twilight Innovations Private Limited. It is a small company. Yes or no? None of you wrote it's a small company?
I wrote it this one.
It's a small company only, no? Okay, now see here. They see da. Okay, now concentrate. That's why you have to read completely da. For a reason, they will give the entire information. Small company, everything is correct. You guys only saw turnover and paid up capital. Who cannot be a small company? Subsidiary and a holding company can never be considered a small company. Section 8 company cannot be a small company. Statutory companies cannot be considered a small company. Now the question is, if they have written everything, definition correct, should we give them? Don't give anything. 0 marks only you give. Okay, na? That's all. Hey. Yogita, this is called entrenchment of articles. No. Don't go with that mindset. You will not get only you go. Okay, now see the. So is it a small company? No, because it's a holding company. You have to write section 285. You have to write. Okay, give that. You should actually not give, but okay, give 1 or 2 marks you give. Papa. Hamara bache. Huh? Hey, she has written at a small company. Cut entire mark down. No, you have to write. Radian Infra, then why did they give 39 crore and the thing that? Okay, now concentrate. My voice is going down. Radian Infra Limited, a listed company, last changed its name in August 2023 to reflect its infrastructure business. In Jan 2024, the company diversified into green hydrogen manufacturing, a line of activity not reflected in its current name. By June 2024, 55% of its revenue came from the green hydrogen division, but only 35% of its total assets were invested in the new activity. In July 2024, the board proposes changing the company's name to Radian Hydrogen Solutions Limited. However, a few object. You are appointed as a compliance officer. Examine whether Radian Infra Limited can proceed with a name change. Can they? Can they or can they not? They can. Why not, Srishant?
Because sir, they're
55 percentage.
no sir.
Ah.
Suppose
Hey, possible for Delta. Possible. Go home. Huh? Matthew? I didn't expect that from you.
50% also should be done, sir.
Ah.
Presenting here, that should be and 50% through the
Ah.
company.
So now,
No, two conditions should be satisfied. One condition is
hey, 2 or 1 revenue or investment it is. Where is and or it was. Take off the entire mark. Don't give. Hey, now what day? There was 3 conditions. Condition number 1 was, first point only was that there should be a cool off period of 1 year. So this is a big case, but answer is only that 1 line. So from the previous name change to this name change, there is no 1 year gap. On those grounds, can the name change happen? Answer is no. Colon, I don't know whether you understood or I understood. I hope you understood the answer. Then that's all.
get their name only in August 24.
But that is
Yeah,
not.
Hey, who got his name? Who got his paper? Hey, don't give 1 mark also.
They can change their name if because 55%.
Provision is wrong. Don't give 1 mark also.
Provision is correct, but
Ah.
suppose the answer is 55%, they can change his name because 55% is correct. But what is the must be okay.
They have written that. Then you can give. But actually you shouldn't give because you should clearly write that it is not possible. Hey, 1 second. See. Hello. Hey, Matthew. I'll throw the bottle from here. Now see here. See. The question is very simple. Examine whether Radian Infra Limited can proceed with the name change. This is your conclusion. Radian Infra Limited cannot proceed with the name change. This should be written. May not. Their discretion and all actually should not be given answer at all. Mark 0. But it's okay, Papa. 1 mark you give. 1 mark. Adu venda. Take off that also. Discount. 4 marks discount. Hey, take off that mark also from him. Say -2 for handwriting. Tell that. Dave, what is the condition? When you are applying for a name change, there should be a cool off of 1 year. Will you take 1 year from the day you apply or from the day they should approve?
They're saying they're only discussing on July 20th. It's just discussion, right?
Srishant, discussion means resolution, noda.
Only board resolution.
Hey, don't give him that. 1 mark I told her, don't give that also. JSI Techno Limited, a mid-sized private company, decided to shift its registered office from one city to another within the same state of Maharashtra due to strategic business reasons. As a compliance officer, evaluate the procedural aspects and outline the legal provisions involved in such a move. Technically, they are saying from jurisdiction of one ROC to another. That's the importance of Maharashtra.
For this question, how should we write the answer? Like if suppose we have this plus arrow and dot, can we write that or it has to be written in?
See, first of all, the question is, can we use the charts in the exam?
You can.
You cannot use it for all the 24-30 questions, but you can use wherever there is a flow chart. But remember, whenever a flow chart is used, you need to explain the provision as well. You cannot write like this, ROC company, this is not accepted. You need to explain the step. Hey, what he is sitting next to you, or to understand ROC is giving something to company. How will they understand? If your flow chart is so much informative, self-explanatory, then I don't mind. But if you ask me, procedure, chart is there, you need to also write at least something. You didn't ask me before. In my chart, is it self-explanatory? That's all. If your chart is self-explanatory. your paper whoever got, for them it will be explanatory, then okay da. You, hey people, they, see that. You're not supposed to write shortcuts in the exam. Shortcut means what? MOA, AOA. MOA is a shortcut.
Sir, while starting,
ROC. You're not supposed to write. Then how to write? See here. When you're writing the word memorandum of association, first time write down memorandum of association. And write MOA here. And in the next lines, in the same answer, in the next lines, you can use the word MOA. But for that, you need to use it somewhere as a full form and then write in brackets MOA. If someone has written shortcuts, at least deduct 1 mark for every question.
Forms also should be written full name.
Form doesn't have a full name, da. You need to write it as INC only. If someone has written incorporation 24, deduct the entire 5 marks for him. I have told this also in the class.
Very silly, but government encourage GOBT.
No.
What is the first time you read the
See, GOBT is not even an accepted norm. So you're not supposed to use a shortcut at all. Hey, people, 1 second. Hey, using shortcut also, it should be an accepted norm. SEBI is the accepted norm. Securities Exchange Board of India, we do not use. We use it as SEBI. So we write it as SEBI.
Even ROC knows.
Yes, that's why I'm saying you have to write it as registrar of companies and then ROC and then use ROC. No, not at all. Board resolution specialization don't use shortcut at all. Shortcuts can be used only for accepted norms. Accepted is SEMI, Limited, LTD, MOA, AOA, NCLT, ROC, RD. Okay. Okay. What is the procedure? You need to take RD's approval from INC 23. And you need to make sure declaration is to be given. Whoever has not done declaration part, don't give them even 1 mark also. We saw declaration, no? Should be given by KMP and 2 directors, sir. They are not defaulting creditors. That if they have not written, don't give a mark also. Here, allo. Okay, done. That's all. So evaluate and come the paper. Tomorrow we'll see the leaderboard. Yeah, of course.